Hello everyone. Welcome to the video lecture on intermediate paper number 5, Business Law and Ethics, CMA Inter. Previously, we had discussed on chapter number 2, Indian Contract Act. We had a lecture on discussing on important topics of chapter number 2 and another video where previous year question paper pattern was analyzed. Today, we will be discussing chapter number 3, that is Sale of Goods Act. So, regarding this chapter, the most probable method of asking in question, method of asking question in examination are one, in form of direct questions, there are some set of important topics. For example, caveat emptor, let buyer be aware, or what is contract for sale versus agreement for sale. Another pattern are you will be given a scenario. Analyzing this scenario, you will be asked to give a legal opinion, which is more probable considering the previous question papers. So, through this video lecture, we will be discussing important concepts. Students are advised to go through the chapters, especially examples. By going through the examples, you will be having a fair idea on what will be the answer for particular situations, which is more probable for asking in examination. So let's get started. So, beginning, one of the most important topic, what is contract for sale, contract of sale versus agreement to sale. So, for example, Mr. A enter into contract to sell his car to Mr. B. That is contract of sale. Suppose Mr. A enter into contract to sell his car in a future day to Mr. B, that is agreement to sell. The key difference between contract of sale and agreement to sell is one is happening now, another is going to happen in future. Contract of sale is an executed contract. It has been executed. The aspects and the conditions of the contract are being already executed. Whereas agreement to sell is an executory contract. This is the key difference between the both. Students are expected to give this wording exactly for scoring. So contract of sale is an executed contract, whereas agreement to sell is an executory contract. Contract of sale, it happens for a good that is happening currently or existing now, whereas agreement to sell, it is regarding a future or a contingent good. If the goods are destroyed, the loss fall on buyer despite the goods are in the possession of seller. Correct. Whereas if the goods are destroyed, loss fall on seller despite the goods are in possession of buyer. So in the case of destruction of good, so contract of sale, liability is on buyer, whereas in agreement to sale, liability is on seller. And another important point students are requested to go through is the definition of goods, because in practical life also the definition of goods as per Sale of Goods Act is referred frequently. Why? Because you will be surprised to know the definition of goods under Sale of Goods Act even includes shares, securities. So one is expected to go through the definition, which is frequently referred even in practically. So seller can sue the buyer for price and for damages in case of breach by the buyer. The seller can sue for damages only in case of breach by the buyer. If you understand the concept, you will be easily able to differentiate much more easier. If it gives buyer to enjoy the goods as against the world at large, including the seller. It gives a right to buyer against the seller to sue for damages. In the absence of lien over goods, the seller is to return goods to official receiver as assignee. He is entitled to get dividend declared by official receiver, which will be at a reduced rate. The seller is not bound to be part with goods until the price is paid to him. The buyer becomes the owner and is entitled to recover the same from the official receiver or assignee. The buyer cannot claim the goods but the dividend declared by official receiver or assignee. So this difference, minimum 5, you should be well aware. There is a good chance for in examination for this to come. What are the essential elements of a contract of sale? You can go through. These examples and all you can go through. We are going through the important topics. So what is the effect of destruction of good? Unless otherwise agreed, the goods remains at the seller's risk until the property therein is transferred to the buyer. It's as simple as this. So, who is responsible in the event of destruction of goods? Once until the good is transferred to the buyer, the liability is on seller. Once it has been transferred, the liability is on the buyer. So, for example, A is selling his car to B. Suppose A is still in possession of the key and is at to enter the agreement. Anything happening to the car will be liability on A. Once the agreement is ended and key is handed over, B becomes liable. Another frequently asked question are transfer of title by non-owner of goods. Even though a person who may not be the owner of good, he still has a right to sell in certain cases. So that are given below. Sale of mercantile agent, transfer of title by estoppel, sale by a joint owner, sale by a person, possession under voidable contract, sale by a person, sale by a seller in possession after sale. These are all different cases of scenario where in question examination a scenario may be given and you are required to identify and which heading that scenario comes under. So one important is mercantile agent. What is it? If a mercantile agent is authorized by owner of the good to sell on his behalf, then such sale shall be valid. In such cases, the buyer can acquire a good title of goods. The exception will be implemented subject to the fulfillment of following conditions. The person must be in possession of goods or document of title to goods in his capacity as a mercantile agent and with the consent of owner. The person must sell goods while acting in ordinary course of business. So let me tell you something. Mr. A acquired a car from Mr. Z, but it is under EMI, or you will say, call it as what? Let's call it simple words. So in EMI, he is buying the car. So what happens? Only after the payment of last due amount of EMI, the car becomes the possession ownership of A. Until that, the car belongs to Mr. Z as per the concepts. Mr. A then sell his car to Mr. B. So Mr. A has no authority. Then, but Mr. A act on full confidence and made Mr. B believe he is the owner of the car, and Mr. B bought the car. So in this scenario, who is the owner? Since Mr. A was never an owner, it was the responsibility of Mr. B to understand, or he never, the right to the car was transferred to Mr. B. So even though mercantile agent says what we just now discussed is not mercantile agent, is an example. But what mercantile agent is saying is, suppose one person is owner of a good, he has the right to authorize somebody else to act on his behalf. For example, Mr. A, owner of car, is authorizing Mr. B to sell his car on his behalf to another party. So, with the consent of owner, a person can authorize somebody else to act on his behalf. That is sale by a mercantile agent. Even when doing so, just now we discussed a scenario only when right has been properly transferred, such a sale can be executed. So, sale by a mercantile agent is a party authorizes another party to act on his behalf. So, first is for a valid mercantile agent sale. First is the person must be in possession of good. This is the most important key factor. So, since in our earlier example, Mr. Z never transferred his right to Mr. A, Mr. A can never transfer or sell that car to anybody. So, Mr. B is not liable for suing or considering it as a sale. Next, the person must sell the goods while acting in ordinary course of business. The buyer must act in good faith without having any notice at the time of contract that the merchandise agent has no authority to sell the good. So, first is sale by a mercantile agent. Next, transfer of title by estoppel. This exception is based on principle of personal estoppel. Sometimes the real owner may lead the buyer by virtue of his conduct or words or by act to believe that seller is the owner of the goods and has the authority to sell them. In such case, he may not be thereafter deny the seller authority to sell. So, Mr. A is standing in front of a Mercedes Benz, and even though he is not the owner, he is acting as if he is the owner. So, he entered into a sale and made Mr. B purchase the car. This is the same case where we earlier discussed it. So, once the car has been transferred to Mr. B, in our earlier example, we discussed Z is the owner. Until Mr. A pay full the money, Mr. B cannot have the title to goods. In this scenario, principle by estoppel, Mr. B will be able to sue Mr. A because of principle of estoppel. Mr. A made believe Mr. B on his action that he is the original owner. Certain times, because of a person's actions, if a party becomes on the belief that he is the actual owner, then in such cases, any aggrieved party will be able to sue Mr. A. But right will always be with Mr. Z only. Possession of good will be with only with Mr. Z. So these are two important concepts. Sale by a joint owner also you can go through. If there are several joint owners of a good, one of them if has stalled possession of goods by permission of co-owner, then property is goods in transferred to any person who buy them from such joint owner. In order to apply this exemption, following condition must be passed. One of the several owner must be sole possession of goods. The joint owner must have permissions of co-owners. The buyer must purchase goods in good faith. The buyer should have notice regarding the matter that seller has no authority to sell. So, suppose there are more than one party to a good or one more than one owner, and if buyer is not aware of any mischief, then what is it saying? There are several joint owner of goods. One of them, if has sole possession of goods by permission of owner, then the property in goods is transferred to any person who buys them from such joint owner. If A, B, and C is the owner of a car, D purchased a car from Mr. C without the knowledge of Mr. A and B. D is protected from A and B. Since C acted on behalf of A and B, and D is not aware whether A and B was cheated or not. So even single party to a joint ownership act on behalf of a good, then buyer is safe. So these are certain level, different types of exemption. Hmm? You can go through the important acronym. Nemo that quote non-habet means that no one can give that he himself does not have. Suppose there is a concept called caveat emptor. Let the buyer be aware. So anybody who buys good should be responsible for the purchase. So it is always on the responsibility of the buyer to be aware. Okay. For that, some exemptions we have discussed it just now. No one gives the what he himself does not have. It means a non-owner cannot make valid transfer. So this acronym you can go through. You can just remember maybe one word or one mark or some simple direct question can come. So practically always it is the responsibility of buyer to be aware. A person who does not have any right or ownership on a good cannot transfer ownership to another person. For that, certain exemptions are sale by mercantile agent, transfer of title by estoppel, sale by joint owner, so and so forth. Another repeatedly asked question, condition versus warranty. What is a condition? A condition is a stipulation essential to the main purpose of the contract, the breach of which give rise to a right to treat the contract as repudiated. A condition in a contract of sale is fundamental nature for breach of which buyer can repudiate the contract. Warranty. A warranty is a stipulation collateral to main purpose of the contract, the breach of which gives rise to claim for damages but not to right to reject the goods and treat the contract as repudiated. So what is it? I bought a iron box. I used it for one day and it got damaged. So as per suppose if I ended a contract with the manufacturer or seller, can I go and tell since your product has been damaged, I want this to be taken back and give me my money back? No. In that case, warranty will apply. Once the contract has been sale has been completed, then warranty applies. Where any damage happen, you are liable for some, you are having some rights, but that rights is to claim for damages, but not to reject the good. This is the main important difference. In case of warranty, you cannot reject the good. Iron box is yours, but since it has been damaged, you can be paid money or you can get it replaced. But that iron box is on your head. Whereas condition means it is ongoing. Suppose a vendor into contract with Mr. B. Suppose any matter to the contract which is crucial for performance has not been complied, any party to the contract has the right for claiming breach of contract or even have the right to repudiate the contract. So this difference you can go through. A condition is a stipulation which is essential to the main purpose of contract. A warranty is a stipulation which is collateral to the main purpose of contract. So warranty happens after condition. Okay. The aggrieved party can repudiate the contract of sale in case there is a breach of contract. A aggrieved party can claim damages only. The main difference between condition and warranty here, in case of guarantee, in case of condition, the either party can repudiate the contract. They can discharge the contract and even claim damages. In case of warranty, there is only damage. You cannot repudiate the contract. A breach of condition may be treated as a breach of warranty. It's as simple as this. Since warranty happens after condition, in case of condition, a breach of warranty is already included. Whereas in case of warranty, a breach of condition can never happen. This is the main difference. A breach of warranty cannot be treated as a breach of condition. Whereas in case of a condition, breach of warranty can be a breach of condition can be treated as a breach of warranty. So conditions, remedies available for buyer, this and all you can go through. Consequences, implied conditions. Here we are focusing on understanding concept. Maybe the most important or one main object of this chapter is to make you aware of this concept called doctrine of cave tempter. The term means let the buyer be aware. The term cave tempter is a Latin word which means let the buyer be aware. The principle states that it is for the buyer to satisfy himself that the goods which he is purchasing are of quality which he requires. This one sentence will give you a clear picture. So, whenever you are purchasing any product, it is your responsibility to make sure that product is of good. So, this concept should be very clear. Any purchaser of good is always on the prime liability. For that, some exemptions are there that we discussed earlier, estoppel, joint owner, and all. That also you should be aware. Rights of unpaid seller, what is it? A person who has been unpaid, a seller who has been unpaid. That person has the right for lien or retention of good, stop the transit, right for resale, and hold the delivery. So important concept we have discussed. Okay. Thank you.